Hello, welcome to the Kingsley Chronicles. I'm David.
And I'm Eva.
Thank you for visiting our channel.
We hope you enjoy our content, that our experiences inspire you.
Please make sure you smash that subscribe button, give us a thumbs up on the little uppy ticky thingy, and poke that ringly dingly so that you and others can receive the latest content we post on YouTube.
And also, don't forget to visit our website, thekingschronicles.com, for even more awesome content from immigration to traveling, forum, blogs, and more.
Thank you for joining us on our adventures. Stay happy, healthy, and God bless you. Hello, and welcome to the Kingsley Chronicles. I'm David. In this fourth video of our immigration series, we will discuss filing for a fiancé and spouse abroad. If you haven't already seen our green card eligibility video, you can view it by clicking the link above. Please keep in mind that I'm not a lawyer, and this is not legal advice and should not be misconstrued as such. I decided to wrap fiancé and spousal filings abroad together because the processes are somewhat similar. It also doesn't make sense to make two separate videos that total only 5 minutes long when they will basically contain similar information. If you are a U.S. citizen who wants to bring your foreign fiancé to the United States in order to get married, you will need to file a Form I-129F, Petition for Alien Fiancé. This is the first step to obtaining a K-1 non-immigrant visa for your fiancé. The K-1 non-immigrant visa is also known as a fiancé visa. In order to obtain a K-1 fiancé visa, you and your fiancé must intend to marry each other within 90 days of your fiancé entering the United States as a K-1 non-immigrant. Your marriage must be valid, meaning both you and your fiancé have a bona fide intent to establish a life together, and the marriage is not for the sole purpose of obtaining an immigration benefit. If your fiancé marries you within 90 days of being admitted to the United States as a K-1 non-immigrant, he or she may apply for a lawful permanent resident status in the United States or get a green card. If you have already married, plan to marry outside the United States, or your fiancé is already residing legally in the United States, your spouse or fiancé is not eligible for a fiancé visa. Eligibility for fiancé visas. You may be eligible to bring your fiancé to the United States on a fiancé visa if you meet the following requirements. You are a U.S. citizen. You and your fiancé intend to marry one another within 90 days of your fiancé's admission to the United States on a K-1 non-immigrant visa. You and your fiancé are both legally free to marry. This means you both are legally able to marry in the United States, and any previous marriages have been legally terminated by divorce, death, or annulment. And you and your fiancé met each other in person at least once within the 2-year period before you file your petition. You may request a waiver of this in-person meeting requirement if you can show that meeting in person would violate strict and long-established customs of your fiancé's foreign cultural or social practice, or result in extreme hardship to you, the U.S. citizen petitioner. Process for bringing your fiancé to the United States. The process for bringing your fiancé to the United States involves USCIS, the U.S. Department of State, and U.S. Customs Border Protection. At each stage in the process, background and security checks may be conducted on both you and your fiancé. This may include checks in various databases for national security, criminal history, and other information about you and your fiancé. These checks are conducted using fingerprints, names, and other biographic or biometric information. Step 1. Petition for Fiancé, USCIS. 1. You must file Form I-129F Petition for Alien Fiancé according to the form instructions. This form asks USCIS to recognize the relationship between you and your fiancé. 2. USCIS will review your Form I-129F and the documents you submitted. USCIS may mail you a request for evidence if they need additional documentation or information. 3. If you establish your eligibility, USCIS approves your Form I-129F and recognizes the claimed fiancé relationship. Otherwise, they deny your Form I-129F and notify you of the reasons for denial. 4. USCIS sends the approved Form I-129F to the DOS National Visa Center, NVC. For additional information about filing the petition, see the Form I-129F and form instructions. Step 2. Visa Application, DOS. 1. The NVC forwards the approved Form I-129F to the U.S. Embassy or Consulate where your fiancé will apply for a K-1 non-immigrant visa. This is generally the U.S. Embassy or Consulate where your fiancé lives. 2. The U.S. Embassy or Consulate notifies you when the visa interview for your fiancé is scheduled. 3. Your fiancé applies for the K-1 non-immigrant visa and brings the required forms and documents to the visa interview. 4. The DOS consular office determines whether your fiancé qualifies for the K-1 non-immigrant visa. If the consular officer grants the K-1 non-immigrant visa, it is valid for up to 6 months for a single entry. If the consular officer does not find the relationship to be bona fide, the DOS will not issue a K-1 non-immigrant visa and instead will return the Form I-129F to USCIS. Generally, if DOS returns a Form I-129F to USCIS after it has expired, USCIS will allow it to remain expired. However, you may choose to file a new Form I-129F. Step 3. Inspection at a Port of Entry, CBP. If DOS issues a K-1 non-immigrant visa, your fiancé travels to the United States and seeks admission at a port of entry while the K-1 non-immigrant visa is valid. As with any visa, a K-1 non-immigrant visa does not guarantee admission into the United States. A CBP officer at the port of entry will make the ultimate decision about whether or not to admit your fiancé. Step 4. Marriage. If your fiancé is admitted as a K-1 non-immigrant, you and your fiancé have 90 days to marry each other. Step 5. Adjustment of status, USCIS. 1. If you marry within 90 days, your fiancé, now your spouse, may apply for a green card by filing Form I-485 Application to Register Permanent Residence or Adjust Status. 2. USCIS may mail a request for evidence to your spouse if they need additional documentation or information. 3. You and your spouse will usually be required to appear for an interview. 4. If you were married for less than 2 years at the time the Form I-485 is approved, USCIS will grant your spouse conditional permanent resident status and issue a green card valid for 2 years. Your spouse will need to remove the conditions on his or her residence by filing Form I-751 Petition to remove conditions on residence in the 90 days before his or her green card expires. Each case is different, and the length of the process varies. USCIS processes fiancé petitions in the order they receive them. For more information about current processing times for the Form I-129F, see the Check Processing Times page of the USCIS website. Children of fiancés. If your fiancé has a child who is under 21 and unmarried, the child may be eligible to come to the United States on a K-2 non-immigrant visa. You must include the names of your fiancé's children on the Form I-129F if you wish to bring them to the United States. The children must continue to be unmarried and under 21 in order to be admitted to the United States as a K-2 non-immigrant. They may travel with your fiancé or later, but they cannot travel to the U.S. before your fiancé. If you and your fiancé married within 90 days of your fiancé's admission into the United States, your fiancé's children who were admitted as K-2 non-immigrants may also apply for a green card by filing Form I-485 with USCIS. However, K-2 non-immigrant children must remain unmarried in order to be eligible for a green card. K-2 non-immigrant children should apply for a green card at the same time or after your fiancé. Permission to work. After being admitted to the United States on a K-1 non-immigrant visa, your fiancé may immediately apply for evidence of work authorization by filing Form I-765, Application for Employment Authorization. In this case, your fiancé's work authorization is valid for only 90 days after his or her entry into the United States. Your fiancé may also apply for work authorization at the time he or she applies for a green card. In this case, your fiancé can file Form I-765 together with the Form I-485. In this case, your fiancé's work authorization is valid for 1 year and may be extended in 1-year increments. Failure to marry within 90 days. K-1 and K-2 non-immigrant status automatically expires after 90 days and cannot be extended. Generally, your fiancé and his or her children must leave the United States at the end of the 90 days if you do not marry. If they do not depart, they will be in violation of USCIS immigration law. This may result in removal or deportation, and could affect their future eligibility for U.S. immigration benefits. However, if you marry your fiancé after the 90-day period, you may file a Form I-130 petition for alien relative. Filing for a spouse outside the United States. In order to bring your spouse, husband, or wife to live in the United States as a green card holder, permanent resident, you must be either a U.S. citizen or green card holder. When your spouse is outside the United States, file Form I-130, Petition for Alien Relative. When the Form I-130 is approved, it will be sent for consular processing, and the consulate or embassy will provide notification and processing information. See form instructions for more information. Required documentation. To complete the process, the petitioner must submit Form I-130, Petition for Alien Relative, signed with proper fee, with all required documentation, including a copy of your civil marriage certificate, a copy of all divorce decrees, death certificates, or annulment decrees that demonstrate that all previous marriages entered into by you and or your spouse were terminated, passport-style photos of you and your spouse, see Form I-130 instructions for photo requirements, evidence of all legal name changes for you and or your spouse, may include marriage certificates, divorce decrees, court judgments of name change, adoption decrees, etc. If you are a U.S. citizen, you must demonstrate your status with a copy of your valid U.S. passport, a copy of your U.S. birth certificate, a copy of your consular report of birth abroad, a copy of your naturalization certificate, or a copy of your certificate of citizenship. If you are a green card holder, permanent resident, you must demonstrate your status with a copy front and back of Form I-551 green card, or a copy of your foreign passport bearing a stamp showing temporary evidence of permanent residence. Conditional residence and removing conditions. If you have been married for less than 2 years when your spouse is granted permanent resident status, your spouse will receive permanent resident status on a conditional basis. To remove the conditions on residence, you and your spouse must apply together using Form I-751, Petition to remove the conditions of residence. Note that Form I-90, Application to replace permanent resident card, is not used for this purpose. You must apply to remove the conditional status within the 90-day period before the expiration date on the conditional resident card. If you fail to file during this time, your spouse's resident status will be terminated, and he or she may be subject to removal from the United States. Use our filing calculator to determine your 90-day filing date. For more information, see the Remove Conditions on Permanent Residence Based on Marriage page of the USCIS website. Can my spouse come to the United States to live while the visa petition is pending? If you are a U.S. citizen, once you file Form I-130, your spouse is eligible to apply for a non-immigrant K-3 visa. This will entitle him or her to come to the United States to live and work while the visa petition is pending. To petition for this benefit, file Form I-129F, Petition for Alien Fiancé. Note that you are not required to file Form I-129F. Your spouse may wait abroad for immigrant visa processing. However, seeking a K-3 visa can be an additional method for him or her to come to the United States. For more information, see the K-3, K-4 non-immigrant visas page of the USCIS website. If you are a permanent resident and you have filed Form I-130 for your spouse and or minor children on or before December 21, 2000, your spouse and or children may be eligible for the V visa classification if more than 3 years have passed since the I-130 was filed. For more information on V visas, see the V non-immigrant visas page. We thank you for watching this video. If you liked it thus far, please give it a thumbs up on the like button, and if you haven't already, please subscribe to our channel and ring the bell to get notifications for our future videos in this series. Also, don't forget to subscribe to our Patreon if you want to receive special perks that only patrons can receive. Our next video will detail exactly which evidence will be required and suggested for these processes.